Welcome to the Magna Carta Prelims 2024. This is lecture number 2. Now, at the outset, I have identified 4 commonly occurring themes that the prelims exam has asked over the last 10 years, which are rule of law, due process of law, principles of natural justice, and constitutionalism. But lecture number 2 is not just about these 4 commonly occurring headline topics. These 4 commonly occurring headline topics will have several related concepts, several related theories, several underlying related ideas that are very, very important for the prelims exam. And what I'm doing this year is doing all of them together right in lecture number 2, making it distinctively different from how I've generally dealt with it in the last few years. And this is largely because the prelims pattern has compelled us to make sure that we structure our lectures in this particular manner. So to begin with, I'd like to first show you the matrix of jurisprudence. So when we refer to the matrix of jurisprudence, this is largely what I am referring to. Every possible legal concept, theory, doctrine, anything that you could possibly think of would effectively be in and out of this fairly complex looking diagram, but it really is not. The journey would start with rule of law. I'd explain to you the ingredients of rule of law. We'll go through each of the ingredients of the rule of law in detail. And while we do so, I'll also explain its related applications. And the concept of constitutionalism is effectively based on rule of law. And there are some dominant themes of constitutionalism which overlap with rule of law. We'll cover them in the course of the lecture as well, and we'll apply them as we get to do so. So let's first understand this matrix. I'd like to believe that rule of law is the big bang of constitutional law. It's the big bang of law in general. It's the Higgs boson. It's the start of everything else. It all starts honestly with a very simple choice. The choice is, do you trust the person in power, or do you trust the office that the person holds while the person is in power? So the decision of rule of law actually begins with a simpler decision of rule of man versus rule of law. Now, rule of man simply means that the person in power gets to do exactly what they want to. And rule of law means everything is governed by a law. The law is also made by the man. The law is also made by representatives. But the law is more important than the people who have the power to make the law, implement the law, or adjudicate the law. And that's a distinct difference. The Latin interpretation or the Latin translation of rule of law is lex rex. The Latin translation of rule of man is rex lex. So every country would effectively be choosing what is called between rule of man and rule of law. And most democratic countries, and this is the important part, democratic countries will necessarily choose rule of law. If you are a democratic country, that means rule of law is something that you would compulsorily want to choose. Why? What is the relationship between rule of law and democracy? If democracy is a reflection of public will, if democracy is about ensuring that the aspirations of the people are reflected in the government, if democracy is about the people choosing the people who will govern them, then rule of law ensures that the people in power do the right thing in the right way, in the right manner, for the right reasons. And that is why there is a positive correlationship between democracy and rule of law. Now, there would have been several reasons for several countries to choose between the two. And India chooses to be a rule of law country for primarily 4 reasons. Reason number 1, our colonial history. Approximately 200 years of colonial rule, and the legal part of it, the constitutional legal history, would be dealt with in the forthcoming lecture. The colonial part of it made us understand how perverse and how difficult, irregular, biased organizations of government can be. We know the detrimental laws, the biased laws, the one-sided laws that the Britishers have imposed upon us. And therefore, we always wanted to ensure that we have a fair system of government. 2. Unlike several Western countries, more specifically the United States, where the states collectively came together and said, let's make the United States of America, the states came before the center when it comes to the US. In India, it was the exact opposite. In India, power was transferred to the Constituent Assembly, and it was the responsibility of the Constituent Assembly and the leadership at that time to consolidate and integrate India. Now, for those reasons, India is partially a voluntary federal nation and partially, one could say, semi-involuntary. There were a lot of instances where there was a lot of hesitation, there was a lot of resistance, there was certainly a lot of negotiation. So if you have to convince a princely state to join India, you cannot convince them by saying, you know what, we've got a great leader in power. You've got to convince them by saying, our relationship is going to be governed by a law that's going to be bigger than the people in power when the law is to be operated upon or when the law has to be executed. So our reasons of voluntary and involuntary federalism is a very strong factor in India choosing to be a rule of law country. Thirdly, the sheer diversity quotient makes rule of law an obvious choice. The diversity quotient means, unlike again several countries in the West, India has always been home to all religions, all cultures, all groups. We've always been an incredibly diverse country. We have always been an incredibly welcoming country. So whenever there is diversity, there will always be a majority, there will always be a minority. And whenever there will be a majority and whenever there will be a minority, no matter what kind of a majority, no matter what kind of a majority or a minority, it doesn't matter what the nature might be, diversity will always have the chance of conflict. In such a case, the law must be indiscriminate. The law must be fair, the law must be unbiased. And if actual power is with the law, it will make sure that the majorities don't cross a line and the minorities are adequately protected. But if the person in power has all the law, has all the power, has all the authority to do whatever they want to, then depending on who the person in power is going to be, and democracy is nothing but the law of majorities. So generally what would happen is that a person in power would necessarily, or if not necessarily, most likely come from a majority. And that could be leading to some questionable policy outcomes. So India chooses to be subject to a bunch of laws. Those laws that will stop the people in power from crossing a line and will make sure all interest groups are adequately represented, protected, and taken care of. And fourthly, our socio-economic indicators. When we became independent, as per our first odd census, which was I think conducted in 1951, India's literacy rate was about 15-16%, which means 85% of India could not functionally read or write. The female literacy rate of India was under 9%, which means about 91% of India could not read and 91% of women could not read and write. Now, in a circumstance like that, where literacy is so disadvantaged, where poverty is so disadvantaged, where there are several other developmental challenges, rule of law becomes an equalizing factor. It will protect those in a larger capacity who need more advancement. It will make sure there is some form of equivalence of opportunity, of platform, of ability, of a chance to redeem oneself. And for these four reasons, we choose to be what is called a country based on rule of law. Now, very categorically, the word rule of law is not mentioned anywhere in the Constitution, though the Supreme Court, in a variety of its judgments, have recognized rule of law as a concept. In fact, we also recognize rule of law to be an element of basic structure. But the word rule of law per se does not find any mention whatsoever in the Constitution. It is a Diceian concept, and Dicey was a very, very prominent English legal expert. The full name was A.V. Dicey. It's not relevant for the prelims exam in any manner. So when he had originally written what the concept of rule of law is, he had kept the UK's legal system in mind. And what we know about UK's legal system is the fact that they don't have a single written codified constitution. They were, at least at that time, a functioning monarchy, monarchy with at least some substantive powers. So the original Diceian understanding of rule of law versus what is the globally accepted principles of rule of law, there is a little bit of a difference. So based on Diceian concepts of rule of law, which you would also see similarly in several Indian manuscripts and Indian texts also, there are three basic principles of rule of law, three basic pillars of rule of law. The first of it is called the lack of arbitrariness, the absence of arbitrary power. It is the first and the most important rule of law. When we use the word arbitrary, arbitrary simply means when somebody is doing something on their own. There is no substantive law that is allowing you to do something. You are doing it because you think it is the right thing to do. You are applying your mind or not, but you're independently taking a decision which sounds without any justification. There's not enough rationale for you to do what you want to do. And therefore, arbitrariness is one of the most important dangers to the concept of rule of law. Now, when we say this, what do we mean? We mean that if there is an arbitrary law, or if there is an arbitrary action taken by the executive, which is largely the case, then the law as the supreme of it, the law as the heightened concept of it, the law as the superior entity to it, that loses its charm. When we say rule of law, it means everything happens because of a law. When we say rule of law, means every power originates because there is a law that provides for it. For example, in a few lectures from now, when we do the executive, I will say that the executive powers of the union are coextensive with the legislative powers of the parliament. That's simply an application of rule of law. The powers of the executive to implement the law will only be limited to the powers of the parliament to make the law, which simply also means that the executive can only implement those things on which the parliament has or would have made a law on. And that's the larger idea. So the law is the originator of power. If there is no law, what you're effectively being is arbitrary. So it becomes a very, very important concept. So this means when we speak about arbitrariness, it actually applies more to executive action and a little less to legislative action. So arbitrariness is largely associated also with administrative law. It's also associated with a more complicated concept like delegated legislation, when the executive is empowered to make rules on something. Are they crossing a line? Are they making rules on something that the law has not given them the powers to make rules on? So for example, if there's a right to education rules, it's because the Right to Education Act allows for the right to education rules. But the right to education rules that you've made should be because of what the Right to Education Act allows the Education Ministry to make rules on. So therefore, it is a very, very sensitive concept, extremely important. And therefore, when you have to eventually prove arbitrariness, you would therefore be dealing with two very important legal concepts. First, are you following a procedure which has been properly passed by the law? And second, is the law and the procedure inherently fair or not? And that's why you have procedure established by law and due process of law. Two very, very important interpretations and two very important terms. In fact, procedure established by law is explicitly under Article 21, but due process of law has been interpreted by the courts in several decisions. The most important of it, the most landmark of it, happens to be the Menka Gandhi case. So when you're trying to figure out whether the procedure was fair or not, you have to figure out where there was a conflict of interest, or whether you had given an adequate opportunity to the other person to present their side of the story. So therefore, related to the due process of law, you would have a concept called principles of natural justice. And this is directly related to arbitrariness. Now, procedure established by law and due process of law also ensure the law is good enough to rule us. For there to be rule of law, the law should be worthy enough to rule over us. And therefore, if the law is procedurally sound, the law is substantively sound, then the law is good enough to be above us. And that's also why these become very important hallmarks of rule of law. So which is why you'll see the journey starts from rule of law, comes to arbitrariness, that for there to be rule of law, there should not be any arbitrariness. And how do you ensure there is no arbitrariness? Is by making sure there is procedure established by law and there is due process of law. Are we okay with this? Do we understand this? And if that is the case, to prove due process of law, you must be able to also attach the larger concepts of principles of natural justice. So the journey starts from rule of law, comes to arbitrariness, comes all the way to procedure established by law and due process of law. This is one arm of it. The second arm of rule of law, the second pillar of rule of law, is equality before law. the law cannot be superior to us if it doesn't treat us equally, if it doesn't treat its subjects equally. And very happily, what you have is equality before law categorically mentioned under Article 14 of the Constitution. So this effectively means that the law should not treat the government specially. The law should not treat government servants specially. There should not be an unnecessary amount of immunity unless it's absolutely necessary. So rule of law is heavily dependent on what is called equality before law, because equality before law means that everyone is treated equally before the law. And of course, over a period of time, you'll understand equality just doesn't mean everybody to be treated equally, but it also means that people who should be treated equally are treated equally, and people who are different, who are disadvantaged, where there are special circumstances, and therefore there could be some amount of what is called differentiated treatment, which is why when you study equality before law, you also in the Constitution also understand two very important concepts. Again, both of these concepts are not explicitly mentioned in the Constitution, but have been derived through several Supreme Court judgments, and they are rational nexus and intelligible differentia, which means that by chance, for any reason whatsoever, you are not treating two people the same way. The first question is, the basis on which you're not treating two people the same way, is that basis reasonable? So therefore, rational nexus. And by treating two people differently, you're trying to achieve an objective. So if you are treating two people differently, are you necessarily able to achieve that objective? So for example, let us say your objective is social justice, which means that people who come from disadvantaged castes must be given some relaxations, some special provisions. So you have basically bifurcated people on the basis of, let's say, upper caste and lower caste. Is that a reasonable basis? Sounds like it. By doing this, if you're able to ensure that people from lower castes are able to get better employment, better reservation, better opportunity of education, then it sounds about right. So therefore, equality before law allows you to have some form of equity before law. And the two principles would be rational nexus and intelligible differentia. And both of these, again, are not mentioned in the Constitution, but of course would find some important mentions in several Supreme Court judgments. Now, the third principle of rule of law, as we understand it to be, is the grand old legal spirit. What is law without the legal spirit? But what is the legal spirit? The legal spirit is your ability to go legal. For you to go legal, you've got to have rights. And not only should you have rights, you should also have a mechanism to enforce those rights. You should have the ability to challenge something if it takes away your rights. You should have the ability to question authority, to question government if your rights are being taken away. So legal spirit is effectively the ability or the being to have some legal recourse, some legal correction. And for that to happen, you should have the courts in the country with the powers to review something that is taking your right away, more simply called the concept of judicial review. But again, judicial review is also not categorically explicitly mentioned in the Constitution. It is derived from various articles. It is in fact a part of basic structure. It is extremely important in terms of ensuring checks and balances, which is a natural corollary of separation of powers. But the term judicial review, as the term stands, is nowhere mentioned in any form or manner as far as the Constitution is concerned. And for the courts to be able to independently, for the courts to be able to efficiently review anything that has taken your right away, it mostly would be a law or an action by the executive. In such a scenario, you would effectively require an independent judiciary. A judiciary which is not biased, a judiciary which is not having any compulsion whatsoever to favor a certain side. Again, the term independent judiciary is nowhere mentioned in the Constitution. It is derived through various provisions. One of them could effectively be the collegium system of appointment. And we do recognize independence of judiciary, in fact, as basic structure. In fact, it was because of independence of judiciary being basic structure, we struck down the 99th constitutional amendment as being unconstitutional, as it had proposed an alternate system of appointment to judges, which would involve the legislature and the executive. This alternate system would therefore be called the National Judicial Appointments Commission. So yet again, for there to be rule of law, you should be able to question anything which is taking away your legal rights, and therefore that's called legal spirit. And for you to be able to do that, you should be able to have judicial review and independent judiciary. So if in the prelims they ask you which of the following is an outcome of rule of law, and they say rule of law is related to judicial review, yes, because without judicial review there cannot be rule of law. You cannot decide what is good law or bad law unless there is judicial review. And for you to decide whether there is good law or bad law, you should have what is called independence of judiciary. Now, these are the kind of questions the prelims has been asking of late. They're taking a grand concept and they're linking it to very, very tangible constitutional principles. So therefore, rule of law has three major pillars. Each of these three pillars will have a degree of applications. Now, if rule of law means that the law is more powerful than the people who are implementing the law, and the people who are implementing the law are effectively the state. So the rule of law is effectively a mechanism to limit the powers of the state. And the theoretical understanding of anything that limits the powers of the state is the concept of constitutionalism. And constitutionalism allows you to restrict the powers of the state, allows you to build whatever you can, however you can, to restrict the powers of the state, which is why rule of law is actually the basis of constitutionalism. So there cannot be constitutionalism if there is no rule of law. And this is true because if constitutionalism is to restrict the powers of the state, then the legislature, the executive, and the judiciary are branches of the state. Giving any one of them any superior power of the other will take away the balance, and therefore it should ideally be the law which restricts the powers of the state, and therefore rule of law becomes that entity that restricts the power of the state. And when you build a constitution which is an application of constitutionalism, is nothing but rule of law in very tangible form, which is why the Constitution gives reference to procedure established by law. It's through the Constitution you come up with things like the rational nexus. It is through the Constitution that you're able to come up with things like judicial review. So, therefore, what ends up happening is rule of law is the basis of constitutionalism, yes. And constitutionalism restricts the powers of the state, yes. And therefore, anything which leads to supremacy of law and leads to limiting the powers of the state is effectively interrelated. So, for instance, if the law is arbitrary, that means the law is not treating people equally. And if the law is not treating people equally, it is violating a legal right. And therefore, I have the powers to review that law, and I will be able to do it effectively only and only if I have an independent judiciary. And if the law is treating us unequally, that means either the basis of classification is wrong, or the objective that you're trying to achieve with that classification seems to be odd. And when you do all of those things, you are effectively questioning the way in which the law has been passed, or the way in which the law is being applied, or is the law inherently good or not. So the circle gets completed. So this rather seemingly complex flowchart is actually the heart and soul of the Magna Carta, Indian polity, constitution, and everything else. So think of any constitutional principle that comes to mind. Let's say federalism. Now, federalism is division of powers between the center and the states to ensure what? There is no arbitrariness. And this means that rule of law has a relationship with federalism. And constitutionalism is limiting the powers of the state. The state includes the center and the states. So if I divide powers between the center and the states, what I'm effectively doing is limiting one's power over the other, which is nothing but, again, constitutionalism. So constitutionalism, so federalism applies to arbitrariness, applies to constitutionalism. Take, for example, doctrine of basic structure. Doctrine of basic structure applies to the parliament's power to amend the constitution. They cannot randomly, arbitrarily amend whatever it is that they feel like. And therefore, if they cross a line, if they violate a doctrine of basic structure principle, then because of legal spirit, I can review whether that actually violates the basic structure doctrine. And for me to tell you what is an element of basic structure doctrine or not, I've got to have an independent judiciary. Something as large as federalism or basic structure to something as simple as the powers to issue an ordinance by the president is coterminous with the powers of the parliament to make laws, is nothing but rule of law to ensure there is no arbitrariness, and in case there is a problem, there is legal spirit which allows you to judicially review. So the fact of the matter is, this is the Big Bang. Everything that happens because of this ecosystem. Now, let's break this ecosystem. Let's look at each fragment in a fairly decent amount of detail and understand exactly what each of these mean. Why is this important? And arbitrariness largely looks at executive action. When we say that the law is treating two people differently, therefore it's violating equality before law, it largely looks at legislative action. And the legal spirit looks at the powers of the judiciary. So through the three pillars of rule of law, you're able to identify the three branches of the state. Every possible combination running from one point to the other is possible because of this matrix of constitutional universe. Now with this, we start with the first pillar of rule of law, which is arbitrariness. Now, let's understand arbitrariness. As you were discussing before, arbitrariness is simply when you are applying your mind or not by simply you doing so. There is nothing that tells you to do this. You are doing this on your own accord. So therefore, arbitrariness is largely related to executive action. Now, the executive is doing something. What the executive is doing could be because of two reasons. Reason number one, very simply, would be that there is a law that gives the executive authority some arbitrary power. This is a prelims previous year question, by the way. The question was, if there is a law that gives uncontrolled arbitrary powers to the executive to do something, what does it violate? So what is happening is, the law is giving an authority the power to do something arbitrary, which means the power is flowing from the law. And this is also violating equality before law. This is also violating the fact that the law should be fair and unbiased. So whenever the law is giving executive authorities an arbitrary power, it always violates Article 14. So for example, let us say when there were challenges made to the Prevention of Money Laundering Act because of the kind of powers it had given to the Enforcement Directorate, allegedly the Supreme Court of course upheld the act, but the challenge was effectively on Article 14, that it was giving wide powers, powers which were unreasonable to an executive authority established because of a law called the PMLA. Similarly, sometimes, very, very rarely, the executive authority will do something when there is no law providing for it. You are punishing somebody, taking action against somebody, you're illegally arresting somebody, you're illegally detaining somebody, you are illegally confiscating somebody's property. Under no law do you have the powers to do this. And therefore, when you decide to do this, you are doing this not because a law is giving you the powers to, because you as the executive authority has assumed the powers to do so. It would largely be a violation of Article 21, because you are effectively violating the life or personal liberty of somebody, and there is absolutely no procedure under the law that allows you to do so. So arbitrariness and equality before law have Article 14 in common. They're conjoined because of Article 14. So when I look at the constitutional reflections of it, Article 14 therefore strikes at the heart of arbitrariness. So whenever you are actually questioning that a law is arbitrary, you will actually be quoting Article 14. And that is why one of the aspects of proving arbitrariness is intelligible differentia and rational nexus, which leads to a larger doctrine called the doctrine of reasonable classification, which of course we will do more in detail under equality before law, because that's closer to Article 14. But arbitrariness and Article 14 have a very deep relationship. Because if a law is treating people unfairly and there is no good enough reason for the law to treat people differently, that means the law is being arbitrary. That means the executive authority who has been given the powers under the law to do so is doing so in an arbitrary manner. And in case the executive authority is doing whatever it wants to, and there is absolutely no law that allows you to do so. For example, an illegal detention, that means you're violating Article 21. That's also against arbitrariness. So arbitrariness would be proved through 14 and of course through 21. Another deduction of this in the Constitution would be Article 245, which effectively is correlated to the 7th schedule, which contains the union list, the state list, and the concurrent list. Now, what happens with the union list, the state list, and the concurrent list is they very clearly divide the powers between the center and the states. By doing this, you make sure that anything any state government or a central government wants to make a law on can only do so if it is within their specific respective lists under the 7th schedule. And the second you cross that, you have not only violated the constitutional scheme of division of legislative powers, you've also been arbitrary, because you do not have the power to make a law on it, nor do you have the power to, as an executive authority under the center or the state, to implement something that you do not have legislative backup for, in a manner of speaking. So center-state relations is a very important instrument of, for example, absence of power. And the applications of absence of arbitrary power is effectively immense. So for example, in a way, when you decide to have very clear-cut jurisdictions, the courts can do X, can't hear Y, locus standi principle applies, doesn't apply here, doesn't apply there, jurisdiction, all of those things. It is all largely an impact of what is called absence of arbitrary power. Because if the courts can arbitrarily decide on something, that is also equally a problem. However, in most cases, in a majority of issues, arbitrariness is largely a mischief done by the executive. Of course, you would have in some cases the legislature also doing something arbitrary, but when the legislature does something arbitrary, it hits Article 14 more than the executive doing something arbitrary. What I'm effectively trying to say is, whenever there is arbitrariness by the executive, it will hit Article 14. When there is arbitrariness by a law, by the legislature, it will hit Article 14 more. At the end of the day, 14 is the midpoint between the first two pillars of rule of law, which is the absence of arbitrary powers, and what is also effectively called equality before law. But what we've understood very clearly here is that yes, arbitrariness is when you're doing something without sufficient reason for it, without sufficient legal backup for it. Whenever you do something like this, you are being arbitrary. A closely related word to arbitrary is discretionary. Now, discretionary is a good way to look at arbitrary. A discretionary power means you have the right under the law to effectively do something on your own by applying your own mind. And therefore, discretionary power is effectively a power which you are using because the law, by directly or indirectly, tells you to do so. For example, the Constitution gives the governor constitutional discretion to say, reserve any bill the governor wishes for the assent of the president. Now, that discretion is in fact mandated by law. If the discretion is unreasonable, if you are using your discretionary power in an unfair manner, then it could be arbitrary. So whatever is discretionary is not necessarily arbitrary. But yes, if there's something which is arbitrary, it's because largely they have been coming from some discretion that has been exercised. And in a welfare country like ours, especially the role of the civil service is a career that you aspire to, so rightfully, one could say that in a socialist welfare country like ours, discretionary powers are sort of a necessary evil. Otherwise, it will be very difficult for the bureaucracy to do what it has to do if they had to be bound by every nitty-gritty provision contained in the law. So this is the first pillar of rule of law, and now we move to the second pillar, which is equality before law. Unlike the first pillar, which is absence of arbitrary power, equality before law dominantly applies to legislative action. When a law is being discriminatory in any reason. Now, it can be positively discriminatory and negatively discriminatory. When it is negatively discriminatory, we call it equality before law, which simply means everyone is equal before a court of law. Doesn't matter who you are, doesn't matter how rich or poor you are, doesn't matter what caste, creed, color, religion, gender you come from, doesn't matter if you're a part of the government or if an ordinary private citizen. It is effectively, very categorically reflected under Article 14. And Article 14 also tells you that everybody is not inherently equal. That is a more advanced, a more nuanced meaning of equality. You cannot have someone with high-end sport shoes, fully capable, fully abled, and someone who is disabled and and wearing nothing but just on their bare feet running the same race. There is an inherent disadvantage. So you have to treat different people, you have to treat people who come with different abilities in a different manner. This is called equal protection of law, also categorically mentioned under Article 40. Now, equality before law is a very straightforward application of rule of law. The relationship is, if the law has to be competent to be superior to everything else, that means the law must also be egalitarian in nature. The law in itself must be equally applicable to people irrespective of scenarios. Sometimes scenarios make it compelling for the law to be discriminatory. And let's understand this through some constitutional reflections. So, under the principle of equality before law, it says like should be treated alike, which means everyone who is similar to each other should be treated similarly. But that also means that, for example, let's say there is A and B. They're inherently different. Now there is B, there is C, there is D, there is E. B, C, D, E are different from A. Now, does that does not mean that B, C, D, E should be treated similarly. Unlike should not be treated alike. This is a concept of equal protection of law. This is also the birthplace of affirmative action. This also allows for reservation policies to be there. It is a very, very important, nuanced principle, and thankfully, both equality before law and equal protection of law are explicitly mentioned in the Constitution, which now raises the larger question. And the larger question is effectively this. The question is, all right, I am allowed to treat people differently. How do I do so? For that, the courts have come up with the doctrine of reasonable classification. For you to be allowed to be treated differently, you should be able to fulfill two principles that collectively constitute the doctrine of reasonable classification. If you are treated differently, as I was telling you before, what is the basis of it? And second, what is it that you're trying to achieve? If the basis is reasonable, and by doing so, you're able to achieve something which is also reasonable, the objective is good enough, and by doing this you're achieving the objective, it's called rational nexus. If the basis is reasonable, it's called intelligible differentia. You would apply this concept to adultery, to homosexuality, to positively to reservation, everything possible. Article 14, as we will discuss when we come to the subsequent lectures on the same, is the backbone of any constitutional challenge. It is underrated, which is why Article 14 is a prelims favorite topic. Not as much for the mains, because in the mains you will see 19 and 21 to be the stars of the show, because issues directly originate from there. But Article 14 is where the constitutional complexity and the constitutional conceptualization lies, which is why Article 14 and issues around these are an absolute prelims favorite. So therefore, if you're doing this, you have to fulfill reasonable classification. It could apply to a presidential immunity under 361. It could apply to an immunity to report true legislative proceedings under 361A. It could apply to diplomatic immunity. It could apply to parliamentary privileges. As I said, it could apply to adultery, to homosexuality. It could apply to right to education in private institutions. Literally everything has to be true, has to pass equality before law. The third principle is that the law itself should be fair, which is exactly what we've been saying for all this while, that for there to be rule of law, the law must necessarily be good enough. And for the law to itself be fair, reasonable and just, you add Article 21 with a little bit to Article 14, and you come up with the concept of due process of law, which has been evolved and applied. It's a US concept, evolved and applied to India through the Menka Gandhi case. Of course, the differences between due process of law and procedure established by law I will do in greater detail when we do preamble, rights, duties, directive, principles. But from a concept point of view, I think this is something that we must know. Now, so this means that arbitrary power plus equality before law is somehow leading us to what is called due process of law, because arbitrary power or the absence of arbitrary power means that there is nothing which is unfair, unjust, unreasonable in the way an action has been executed by the executive. The law itself should also not be unfair, and you add both of these concepts together, what you effectively get is due process of law, which is why, and this is also why last year in 2023 there was a remarkable question. So let's address it in detail in line with PYQ trends. So when we are referring to due process of law, we are trying to say that that anything will pass the test of due process of law if it is able to prove no arbitrariness in executive action and or no arbitrariness in terms of the law. The law is not unfair, the law is not unreasonable, the law is not unjust, the executive has not been arbitrary in implementing it. If either of the two or both are being fulfilled, then you would have what is called due process of law. Now, the larger umbrella term is due process of law. What the Constitution under Article 21 mentions is procedure established by law. Now, to explain the difference between them, I'll take a simple example. So we understand that there are three branches of the state, L, E and J. That's one parameter. And in the first lecture, you would have understood there are two kinds of laws. One is called a procedural law. The second is called a substantive law. So let me tell you, let's say for example, let's make a law today, and let's say drinking tea in the afternoon is a crime. Now this is a substantive law. And if I make another procedural law and I tell you that if you have been charged with drinking tea in the afternoon, you will not get any legal representation. You don't have the right to hire a lawyer. You will not have the right to be represented by a lawyer in a court of law. So this effectively means that this is a procedural law, this is a substantive law. Now keep this in mind, and now let's understand the three basic versions of it. The first is the pure form. I call it pure due process or procedure established by law. This means whether both of these laws were passed in the right manner. no matter what is inside the law. If the law is passed in the right manner, both the houses passed it, the president gave the assent, published properly in the gazette, all done, all procedures taken care of, it doesn't matter what is inside the law. It's a very narrow understanding, but it's the textual understanding, which basically means that as long as the law has been passed using the right procedure, as long as the law or any restriction which is effectively based on some law which has been passed in the right manner, the procedure has been rightly put into place, as long as that happens, you are good to go when it comes to procedure established by law. This also means that it is largely applicable only to the executive. Now understand this. If I tell you from a very simple textual meaning of procedure established by law, it means, let's say something has violated procedure established by law, which means the law tells you there is a procedure, the authority has to implement that procedure, the authority has not implemented that procedure. The authority is the executive, which is why procedure established by law is only and only applicable to executive action. For example, let us say there is an income tax law under which an income tax authority has the right to, let us say, inspect your documents. But before they do that, they have to send you a notice. If they don't send you that notice, they have violated a valid procedure established by law. That's what it means. It is explicitly given under Article 21. So by this reason, both of them are perfectly okay. There's nothing wrong with both of them, because both of these laws were were rightfully passed using the right procedure and are being implemented the right way. So therefore, you need to make this better. Just because something has been passed the right way does not necessarily mean that it is right. Tomorrow I could make a law saying growing a beard is criminal. I would be in jail. So therefore there is a problem there. Or let's say if I grow a beard and the police could just take me and put me behind the bars without allowing me to contact, let's say, my relatives. There's something wrong with the procedure. There's something inherently, fundamentally unfair about that procedure, which is why you need to take a step up. And that's exactly what happened in the Menka Gandhi case, where the Supreme Court said, irrespective of the fact that the procedure was rightly passed and the procedure was rightly followed, but was it the right procedure to follow? Is the procedure in itself a good procedure? The fact that you do not have any legal representation, is that okay? Is that justified? Is that all right? Is that acceptable? The answer is a clear no. So therefore, according to procedural due process, or PEL plus, this procedural law can be declared invalid. The basic understanding is procedural due process applies only to procedural laws, and therefore procedure used to implement the law, is that procedure fair or not? So that is what is meant by procedural due process. Now, is the procedure fair or not? How will you know? When I don't give somebody legal representation, I don't give them the right to be heard. I don't give them the right to a fair trial, the right to a fair hearing. And all of this is a part of a larger principle called principles of natural justice. And this also links straight up to constitutionalism, straight up to rule of law, which is why in 2023, when they asked you, principles of natural justice means what? It means fair application of the law. So procedural due process, or PEL plus, is effectively nothing but was the procedure inherently okay or not? And this is your titanium line for the prelims exam. Procedural due process, as defined by Menka Gandhi, is only and only applicable to procedural laws. So in the Passports Act 1967, which gave the powers to the government to ask Menka Gandhi to surrender her passport, the Passport Act was questioned because the Passport Act did not allow for her to actually give her side of the story. It was an unfair procedure, which is why it is procedural due process, which is closely linked to principles of natural justice, which I will now discuss in just a few minutes on the next page. And then you have the best of it all. Is the procedure fair or not? And is the law in itself good or not? Is it okay to criminalize having tea in the afternoon? Does it even make sense? Why would you criminalize having tea on a hot, lovely afternoon in the winters? That is just wrong. That is just unfair, unjust, and unreasonable. So this is something that will therefore apply to both procedural and substantive laws. Menka Gandhi's case did not speak about this. It spoke about this. And therefore, when you're questioning the law itself, that means you're questioning the substantive law. Law says X is wrong, but that doesn't seem right. Why should X be wrong? That is called substantive due process. Now, this has been used on so many occasions in so many different ways, means and forms. For example, 1978, just a few months after Menka Gandhi's case in the Sunil Batra case. Here, the issue was that a person who was to be convicted and therefore sentenced to a death penalty would be kept in a separate prison. Doesn't seem to be a fairly right thing to do. Constitutionality of the death penalty. It seems unfair, unjust for the state to take away your life when the state has not given you life. Decriminalization of homosexuality. It is unfair, unjust, and unreasonable to criminalize people who are privately being intimate with people of the same gender. It could apply to transgender rights. It could apply to entry of women into the Sabrimala temple. It could apply to abortion rights. It could apply to privacy rights. It could apply to Section 66A of the IT Act. Anything and everything which declares a fundamental law to be invalid because the substantive law is fundamentally unfair is what is called substantive due process. Now, going back to 5 minutes ago when we were speaking about principles of natural justice. Principles of natural justice is to check the fairness of the procedure, is to check whether the procedure is fair or not, is being applied fairly or not, is the procedure inherently a good procedure or not. It's not about the substantive law, it's about whether the procedure is okay or not. So for example, you're questioning the way the ED would function, or for example, you may want to question the way the CBI would function. You may want to question the way any other intelligence agency would function. That is, or let's say issues with the NIA Act, for example. So your issue would be with procedure. But if you're questioning whether the Unlawful Activities Prevention Act powers to declare an organization to be unlawful, is that fair law or not? That would be substantive due process of law. So now let's take a magnifying glass and let's look at principles of natural justice. Now, because there's been reference here, let's understand quickly. Procedural due process, or PEL plus, means is the procedure fair or not. It means whether the procedure has been fairly applied or not, is the procedure inherently reasonable or not, which leads to my larger principles of natural justice. Now there are two Latin terms, nemo judex in causa sua and odi alterum partem. It simply means rule against bias and the rule of a fair hearing. So which means if there is any conflict of interest in any form, in any manner, that could be favoritism, that could be a positive bias, that could be a negative bias. For example, one of the things that contempt of court is severely criticized for is effectively rule against bias, nemo judex in causa sua. Because what happens in contempt of court is you've disrespected the court and the court is initiating contempt proceedings against you. The person that you have harmed is the person deciding whether they have been harmed or not. There's a clear conflict of interest. So there could be a personal bias, there could be a pecuniary bias, there could be a substantive bias, there could be an administrative bias. So any bias of any kind, any conflict of interest of any kind is effectively a violation of principles of natural justice. And then you have something called the rule of fair hearing, which simply means you have the right to be heard, you have the right to question evidence, you have the right to be shown the kind of inquiry that has been committed against you, you have the right to know why you've been charged with something, which is why, for example, Article 22 is a huge question mark on the rule of fair hearing, because under preventive detention you do not have the right to seek a legal counsel, because preventive detention goes against the fundamental concept of a fair hearing. And with fair hearing, there are two concepts. One, there's something wrong that you've done. Before finally deciding what you've done is wrong, they have a hearing. This is called pre-decisional hearing. The second way to do this is, you've done something wrong, and therefore they've decided that you've done something wrong, and they've taken action against you. Now, after they've taken action against you, then you can question the action that has been taken. So preventive detention is actually an issue of post-decisional hearing. It's also included in odi alterum partem. In fact, in the Menka Gandhi case, this was exactly the problem. She was asked to surrender her passport, she was ordered to surrender it, and then she was asked, oh, by the way, do you care to explain yourself? So these are your two basic principles, and in the modern world that we live in, we also now have a modern principle of natural justice, which is nothing but the doctrine of reasoned decisions. Now, the doctrine of reasoned decisions, as we understand it to be, is that if somebody is giving a decision against you, they've also got to tell you why they're saying so. They've got to tell you what is the basis on the basis of which they've said you are wrong, this is why you are wrong. Of course, in all of this entire ecosystem, there will often be some terms and conditions. For example, an emergency. For example, a specific law that provides you or exempts you from, let us say, the right to a fair hearing or the right to be heard. There could often be cases where administratively you could be prevented. There are enough and more exceptions that can happen on a day-to-day basis. But largely, again, because procedural due process or procedural fairness largely applies to procedural laws, and the problem is that procedural laws are largely executed by the executive. You will mostly see principles of natural justice applied to executive actions. It could apply to other also, but mostly it is done so for executive actions, which is why Article 311 Clause 2, wherein a civil servant, you are constitutionally protected that you cannot be removed without an inquiry against you, is nothing but a principle of natural justice. The problem with 3112 is, do you get to be shown a report of the inquiry against you? That becomes a question mark on the principles of natural justice. Nonetheless, these are your three pillars of what I call rule of law, what the world calls rule of law, with applications to real-time constitutional principles, just the way UPSC asks them in their prelims exam. From here, we now move to the legal spirit, the third and the final pillar of rule of law. Now, as I said, legal spirit is the spirit of being legal. Now, this effectively means two things. One, not only do you have rights, but you also have enforceability of rights. If you don't have rights, you don't have a legal spirit. Rights is a form of guarantee. Unless you don't have a right, you don't have anything to go to court for. And A and B, you have a right, but you don't have a right to enforce that right is a problem. So enforceability. And generally how your rights are violated. They're violated because a law is wrong or an executive is wrong. And that is the larger concept of judicial review. Judicial review means two things. One, the review of legislative action, and two, the review of executive action. Of course, the courts also evolve. Also, lower courts' decisions are reviewed and appealed by higher courts. So generally, when a higher court is reversing a judgment of a lower court, we don't use the word judicial review because you have what is called an appellate system in place. We have an independent and an integrated judiciary, and the higher courts, the Supreme Court and the High Court, are courts of record. This is something that I'll teach you in more detail when we do judiciary, but basically a court of record is something which is to the effect that anything presented before the court is a part of substantive proceedings and substantive record of the court. And two, the courts have the power to review their judgments, to keep evolving their judgments. All of this is in the larger spirit of something called the legal spirit. So whether it's court of whether it is court of record, whether it's suo motu, whether it's PIL, whether it is, when we look at from a constitutional reflection point of view, Article 13 Clause 2, which says no law can violate a fundamental right, which means if a law violates a fundamental right, the courts figure out whether the law was right or wrong. Similarly, if your fundamental right is violated under 32, you could go to the Supreme Court. This is an enforceability law. If any legal right has been violated, or even if your fundamental right is violated, not only can you go to the Supreme Court in case of a fundamental right, you also have the option and the choice to go to a High Court. If your fundamental right is violated, you also have the option to directly go to the Supreme Court. In case your constitutional right or a statutory right or a legal right is violated, you can go to the High Court under 226, which is again nothing but an enforceability clause. The jurisdiction of the courts, original jurisdiction, advisory jurisdiction, extraordinary jurisdiction, appellate jurisdiction, writ jurisdiction, all of these are nothing but instruments of legal spirit. So if they ask you, for rule of law, Article 32, constitutional remedies is a natural outcome, that is a perfectly valid statement. Because if you don't have the powers to enforce a right, you have violated legal spirit, and legal spirit is a necessary ingredient of rule of law, which is why the first matrix flowchart that we made is effectively the most important. And this makes me finish the ecosystem of what is called rule of law. Now, the final part of it, constitutionalism as we understand it to be. See, first things first, we figured out the relationship between rule of law and constitutionalism. Rule of law is to ensure that power originates from the law. Constitutionalism is limiting the power of the state. So when power originates from the law, which means the law will decide how much power you have. So the law is a limiting force on power. Constitutionalism also speaks of limiting power. Who has power? The state has power. And the state has four ingredients: got to have territory, got to be sovereign, there needs to be a functioning government, and there need to be people. If you have these four, you can philosophically call yourself state, which is again a PYQ question asked before. Now, so constitutionalism is nothing but the idea of limited powers. Now, when I say constitutional government, this is also a PYQ. A government whose powers are restricted. So constitutional government means a government whose powers are restricted. So does that mean a constitutional court is a court whose powers are restricted? No. A constitutional court is a court which has the powers to pronounce the constitutionality of laws, whether the law is good or not. So the court is limiting the powers of the state by having the powers to review what the state does, which is basically pass laws. So when the Constitutional Court performs the function of judicial review, it is effectively performing or upholding the larger principle of constitutionalism, which is why the two constitutional courts in India are the Supreme Court and the High Courts of various states, because what they effectively do is pronounce upon the constitutionality of certain laws. This does not mean that the powers of the court are restricted. Of course, the courts also have the powers within the constitution. The courts can only do what the constitution allows them to do. So for example, let us say the advice given by the Council of Ministers to the President cannot be inquired by a court of law. So yes, to that sense, you're also limiting the powers of the court. For example, let us say if something is in the 9th schedule and does not violate basic structure, the courts cannot review it. That's also limiting the powers of the court. For example, orders of the Delimitation Commission cannot be reviewed by a court. That's also limiting the powers of the court. But when the courts have the powers under 131 to do anything in the interest of natural justice, that is a constitutional court. When the courts have the powers under 32 and 226 to issue writs to enforce rights, that's also the function of a constitutional court. So a constitutional court effectively has a two-dimensional meaning. The more important meaning is that you could pronounce the constitutionality of laws. They've asked you this, they've asked you this, they haven't asked you this. It's only a matter of time the UPSC asks you this. And we've got to be a step ahead of the commission when it comes to the exam conducted by them. So constitutionalism effectively means limiting the powers of the state. Now, the best way to do this is we can't give any of the agencies of the state any such powers. We've got to do it by law. And therefore, rule of law also kicks in. And therefore, we have the concept of constitutional law. Constitutional law is any means through which you're limiting the powers of the state. So it could mean a law, it could mean a case law. For example, when the Constitutional Court gives a judgment which limits the powers of the state, let's say through the doctrine of basic structure, it is effectively undertaking constitutionalistic pursuits. Things like if you're appointing the governor, you have to speak to the chief minister. You're restricting, in a way, a power. If the no confidence motion has been passed, then the Council of Ministers must conventionally resign. It, of course, is a matter of convention. So, things like these, you're limiting the powers of the Council of Ministers because what you've effectively done is the fact that you have lost confidence of the House. Something very specifically in a law, that the Council of Ministers are collectively responsible to the lower house. That means you're limiting the powers of the Council of Ministers, which are an instrument of the state. So what you effectively are doing is constitutionalism, right? And therefore, constitutional law is everything that limits the powers of the state. And one of the ways to do this is through a law called the Constitution. It's a law, but it's a law that has a special meaning to it. Now, I'm going to tell you the purpose, I'm going to tell you the types, and then we're going to specifically focus on written constitutions. So bear with me, because we are a written constitution. Now, I've given you two purposes. One is a principal purpose, which is a constitution is any document which effectively gives you a structure to the government and the relationship between the government and the citizens. But as per our NCERT's class 12th India's Constitution at Work first chapter, there are four basic functions of the Constitution. One, it lays down the basic rules. Two, it decides who has the powers to make decisions. It tells you how the government should be constituted. Three, it also gives you limitations on the powers of the government. And fourth, it also enables the government to fulfill the aspirations of society. This is directly from your NCERTs. In case any of these options are in the options that are there in the prelims exam, you've got to mark them right, because the NCERTs are in fact the ultimate truth when it comes to the polity part of the exam, apart from the Constitution. Now, when we say the Constitution, it simply means a legal document. Now, it could be written or unwritten. A constitutional law is fairly similar to an unwritten constitution, in a way that any law which limits the state is constitutional law. So the basic difference between a written constitution and an unwritten constitution, very, very specifically, is a written constitution means there is one law that covers all of these four things. It does not mean it is the only law that covers all of the four things. It is that one law which covers all of these four. You could have a second law which will cover point 1. You will have a third law which will cover point 4. You will have another law which will cover point 2 and 3. But there's a primary law, and this law therefore becomes superior to all other laws. Which is why we often say, for example, Article 13 Clause 2 says, as we were discussing earlier, no law can violate a fundamental right, which means fundamental rights are in the Constitution. So any law made by the Union or the states, any ordinary law, therefore means that you cannot make any parliamentary or state law that violates something which is in the Constitution. And fundamental rights, by the virtue of being in the Constitution, get some special treatment. Similarly, you would have heard of things like constitutional bodies. The fact that they're in the Constitution allows them to get some special protections, like their salaries cannot be disturbed, their tenures cannot be diminished to their disadvantage, their expenditures and the salaries, etc., are to be charged to a consolidated fund of India, which means that they cannot be reduced. They aren't even voted whenever the budgets are passed. So therefore, you have certain advantages of having a primary law. It therefore creates what is effectively called sort of a supremacy of it all. It is also a very good way to uphold constitutionalism and effectively rule of law. An unwritten constitution means there are 4 different laws covering 4 different parts, covering 4 different areas. They're as important as each other, which means the legislature in an unwritten constitutional setup, let's say like the UK, would have equal powers to add, subtract, deduct, whatever you want to. But in a written constitution, because there is a single law, everything is written in one document primarily, you could restrict the powers of the parliament to make changes to it. And if you're making changes to the constitution, you would classify them as a separate set of changes called constituent powers. So the parliament has 2 kinds of powers. Constituent powers under 368 to amend the constitution, and ordinary powers under Schedule 7, Union List and Concurrent List, to make ordinary laws on legislative subjects. So ordinary legislative powers and constituent legislative powers are very different things. You can only make that difference because there is a written constitution, right? This is one way to do this. This is on the basis of what is called codification. The second way that you could do this is on the basis of the level of government that you have. If you have a single government, then it's a unitary constitution. If you have more than one, you have two layers of government, it's a federal constitution. And power can never be distributed equally. So therefore, either center will have more powers than the states, or states will have more powers than the center. And it is exactly in this scenario that in a federal constitutional setup, a written constitution makes more sense. Because if there's one single law bigger than everything else, which can tell you this is what the center can do, this is what the states can do, it just makes it easier and therefore more hierarchical. If it was an unwritten constitution, that means the parliament, which is the center, could effectively give itself more powers than the states, and you could ridiculously not do anything about it. So therefore, there are some inherent advantages that India has by being a written constitution. And they are, you ensure there is no parliamentary supremacy. Even the parliament's powers to amend the constitution are restricted through 368. You've been able to come up with something called the doctrine of basic structure. For a federal setup like India, a written constitution makes so much sense because you can clearly allocate powers through a higher hierarchical law. It also ensures that there is better judicial review. If you think about it, in a constitutional setup which has a written constitution, you very clearly can allocate powers to the court to judicially review. And these powers that are given to the courts to judicially review cannot be taken down by the parliament, because the parliament is also subservient or subordinate to the written constitution. And because it is a higher document, it's a supreme law sort of, the parliament can also not fluctuate your rights, so it's better for rights protections. And because you are giving the structure of government in a higher document, so separation of L, E and J, and them keeping a check on each other indirectly through different ways can also be done through this written constitution. Remember, neither judicial review, nor federalism, nor separation of powers, nor checks and balances are anyways explicitly mentioned in the constitution. So this means if your question says, according to the constitution, separation of powers is keeping the branches of state separate, it would be a wrong statement, because according to the constitution means explicitly according to the constitution. And this takes care of your primary advantages of what is called a written constitution. And just to cover the loop, in just one line and nothing else, because if at all there has to be a question, it has to be very simply based. They've never asked doctrines because doctrines can be fairly vague and ambiguous. There are 6 basic doctrines that we've got to know at all times. What are they in one line? You've got the doctrine of basic structure, which means certain principles of the constitution, certain ideas of the constitution cannot be amended. They are defined by the Supreme Court on a case-to-case basis. It applies to both constitutional amendments and ordinary laws. So neither constitutional amendments nor ordinary laws can violate the basic structure. When we speak about harmonious construction is balancing conflicting provisions. It has 2 applications. The first, of course, is, let's say, balancing fundamental rights and directive principles. This very specifically means you can have a uniform civil code, but make sure it doesn't violate freedom of religion. And second is to balance center-state powers. For example, something is in the concurrent list, which means both the union and the states can make laws on something which is in the concurrent list. So how do you make sure such a conflict is resolved? Severability means a law has, let's say, 5 sections and only section 3 is problematic as violative of a fundamental right. You can specifically declare section 3 as invalid. Remember, when the court declares something as invalid, it simply makes it unoperational. The court cannot delete anything from the law. The doctrine of eclipse means simply this, that if there is a law that is being enforced in India, but the law was enacted before 1950, let's say for example the Indian Police Act, because the penal code no longer exists, of 1861, which allows for restrictions on movement. It's also applicable in 2024. You have a particular problem with the section of 1861 Police Act or the Police Act as a whole. It will not be void from 1861 because we don't have the authority to invalidate the effect of the laws before 1950. It is only applicable even if it's a pre-independence law and you're declaring it as invalid. Its effect could only be declared invalid post 1950. They are not void ab initio. Whereas if there is a law which has been passed after 1950, you can declare it void from the start. Colorable legislation simply means what can't be done directly should also not be done indirectly. For example, ordinances. Well, ordinances are structured in such a way that you should not bypass the legislature. So if you try to withdraw the ordinance before the session, or if you try to repromulgate it in a way that you're bypassing the legislature, you're taking away the inherent purpose of an ordinance. You're defeating the larger purpose of parliamentary democracy. What can't be done directly should also not be done indirectly. And lastly, reasonable classification, which is nothing what we've discussed before. It's a combination of intelligible differentia and rational nexus. So it simply means that for you to discriminate or to classify something, the basis should be reasonable, the objective should be fair, and by creating that classification, you're able to reach that objective. The chances of this to come in the pre are less, but just in case, to keep our bases covered, I've given you 6 extremely important doctrines that are applicable in so many different ways. Thank you. This is lecture number 2. See you for lecture number 3, legal history. And you've never done legal history like this before. Thank you for watching. Thank you for being a part of this. See you for lecture number 3. Bye-bye.